Hi, this is Mitarik. We have 5 members in our group: Naresh, Subhash, Utshuk, and Pradeep. So we are going to talk about our case, that is Roads and Traffic Authority versus Dederer, which belongs to 2007. So we are commenced in that in 6 December 2002. But we have choose these things because we have some probabilities about the accident in RTA versus Dederer. So firstly, as per section 5B1, we are talking about the plaintiff needs to provide some enough evidence to suggest that the risk was not foreseeable. This would help plaintiff to ensure that the probability of this injury due to his jump was not reasonably foreseeable application. The plaintiff will also have to establish the negligence created by RTA, which would ensure the probability of his actions to be repeated by a reasonable mean in the place. So the first respondent sued the applicant and the municipality in which the bridge was situated. The second respondent in this matter in the Supreme Court of New South Wales in negligence. The trial judge, Dunford J. Vaughan, in the first respondent against both defendants. He held further that the first respondent had been guilty of contributory negligence and assessed his responsibility for these injuries at 25%. So there are recreational parks on each side in that place of the bridge. The Tunckery Town Centre is about 500 meters to the northwest, and that of Forster about 200 meters to the east. There is a small marina immediately to the north of the bridge, and when that boy is fall down, that 14 years boy, he just broke his head over there, and he injured because he didn't see the sign over there in that bridge. There is a small marina, and the area attracts a large number of tourists. Its population swells during the summer months, and families and children are among those tourists. Some families came annually. And there has been a misidentification of risk. The risk of injury was not because of bridge itself, but because of jumping into shallow water. Therefore, the previous proceedings adjust that there was a great probability because a lot of people used to jump in that bridge. The extent of the obligation owed by RTA was that our roads authority exercising reasonable care to see the road is safe for user exercising reasonable care for their own safety. So now I just hand over to my next group member, who is Naresh. He is speaking about his topics.
Hi, this is Norris, and now I am talking about the negligence. Bridge, stand of clear, prospective assessment of your bridge, characterization of relevant risks, assessment of probability of risks, assessment of gravity of risks, assessment of practicability of presentation and relevance of voluntary conduct and obesity of risks, relevance of allurement, whether Young String Council versus Shorts was correctly applied, negligence, contributory negligence, reduction of damage by Court of Appeal, whether Court of Appeal error in distributing trial judge assessment, Court Appeal limitations on appeal, reveal of finding of facts, meaning of concurrent finding of facts, and the cost, Sanderson's orders, circumstances in which it is appropriate to make a Sanders order, and the rest of the video will be given by Subhash.
Hi, it's me Subhash, the next group member, and my topic is about the High Court decision. The majority of High Court, Gilson, CJ and Krivij upheld the RTA appeal, and Gumau J, who delivered the leading judgment, firstly affirmed the decision in Brody, Slington City Council 2001-206 CLR 512 that the duty out by the road authority was to exercise reasonable care so that the road was safe for users exercising reasonable care for their own safety. In applying this test, His Honor held the RTA did not owe a more stringent obligation towards careless road users, as compared with careful ones. In each case, the same obligation of reasonable care was owed, and the extent of that obligation was to be measured against a duty whose scope took into account the exercise reasonable care by road users themselves. His Honor emphasized that the obligation to exercise reasonable care must be contrasted with an obligation to prevent harm according to the others. The fact that the RTA knew that people were not exercising reasonable care for their own safety in large number in dividing of the bridge did not mean that the RTA owed a duty to prevent them for doing so. Its Honor further stated that in simple and complicated cases like one thing is fundamental. While duties of care may vary in content or scope, they are all to be discharged by the exercise of reasonable care. And the RTA successfully argued that the test for determining a highway authority liability, being the ordinary test of liability in negligence, had not been correctly applied at trial or in the court of appeal. The error was in the lower court finding that the non-fact that individuals were jumping off the bridge called for additional preventive measures to be taken by the RTA. As His Honor Judge Gamau pointed out, the error in that approach lies in confusing the question of whether the RTA failed to prevent the risk-taking conduct with a separate question of whether it's exercised reasonable care. And the next point was of the Supreme Court decision was His Honor pointed out that if a contrary approach were taken, defendant will be liable in any case in which the plaintiff got a warning sign. The approach taken by the majority of High Court was that the party who gave the warning could not be necessarily be found to have a negligent by reason of warning have failed. The trial and the next point of the trial judge's finding. First one, the trial judges found that both the applicant and the counsel owed users of the bridge, including the first respondent, a duty of care. His Honor Dunford just said, "I am satisfied that almost from the time of its construction and certainly for many years prior, the plaintiff, accident young and not so young person were regularly using the railing and ledge of the bridge as launching pads for jumping and dividing into water below, particularly but not limited to during the summer holidays. The reason why jumping and dividing of the bridge was so popular in the part due to the flat-topped railing along the outside boundary of the bridges and the easier of access to that railing by the reason of wooden cross member with provide step up to the stopped railing." Thank you. So I want to hand over my next video to my next friend. Thank you.
Hi, I'm Utsuk. I'm the next group member, and I'm talking about the implications that the case has brought about. The decision affirms the approach taken by the High Court in Yong Shire Council versus Cert 1980, which was affirmed in Yong Shire Council versus Very 2005, that a breach of duty needs to be considered in light of what a reasonable person would have done to avoid the risk of injury. This approach places an emphasis on whether the defendant's response to the risk of injury was reasonable. This test to be applied by asking prospectively what the exercise of reasonable care required in the response to a foreseeable risk of injury, not by focusing in retrospect on how the defendant could have prevented the plaintiff from diving. The court has emphasized that in applying the principles in Yong Shire Council versus Short, the criterion is reasonableness rather than a stringent requirement of prevention of injury. And that's all, and that's the ending of our video. Thank you.